All right, let's talk about something that can be a real headache for homeowners, a fight with your HOA. We're going to dive into a pretty wild situation that asks a huge question. Can the rulebook for your neighborhood actually stop you from getting your day in court? Let's get into it. So let's just put the question right out there. You're convinced your HOA has crossed a line. You do everything by the book, you file a formal complaint with a state agency, and you expect a public hearing. But what if the HOA just turns around and says, nope, you can't do that? Could they actually have the legal power to stop you in your tracks? To figure this out, we're not going to talk in hypotheticals. We're looking at a real-life case out of Arizona. This is the story of Carol M. Root versus the Candlewood Estates at Troon North Homeowners Association. And believe me, this case is a perfect example of how the papers you sign when you buy a house can have some really serious and kind of hidden consequences. So Carol Root did exactly what you or I would probably do. She had an issue, so she took it to the official government body designed to handle these kinds of things, the Office of Administrative Hearings. Now, this isn't a huge courtroom drama, but it's a formal, state-run process. It's supposed to be an impartial venue for people to resolve disputes. But this is where the whole thing takes a sharp turn. The HOA didn't respond by arguing about her complaint. They didn't say she was wrong. Instead, they filed something called a motion to dismiss. You see, they weren't arguing the facts of the case. They were arguing about the location, about where the case could even be heard.
Their entire argument came down to their own internal rulebook. They basically said that when Carol Root bought her home, she automatically agreed to follow a very specific, very private process for any disagreements. And they argued that this private agreement completely overrules her right to use a public state hearing.
So you might be wondering, how on earth can an HOA rulebook be that powerful? Well, it all comes down to a really important legal idea called a restrictive covenant. These things are not just friendly neighborhood suggestions, okay? They are ironclad, legally enforceable contracts that are baked right into the deed of your property. The moment you buy that house, you are legally stuck with these rules. And this isn't some new legal theory either. The judge in this very case pointed back to an older case, Powell versus Washburn, which lays it out crystal clear. A restrictive covenant is a contract, plain and simple. If you buy a property that has them, you are bound by that contract's terms. And here's the kicker. It doesn't matter if you read every single word or not. You bought the house, you agreed to the deal. So what was in this contract that the HOA was talking about? Well, their rules laid out a very specific three-step process. First, you have to send a written notice. Okay, simple enough. Second, you must try to work it out through private mediation. But it's this third step that's the real game changer. If mediation doesn't work, the dispute must go to final and binding private arbitration. The public court system, completely off the table. So this is where the two sides really dug in. On one side, you have Carol Root, the homeowner. She argued that, for one, this whole rule was added to the documents improperly, so it shouldn't even count. And besides, she said the rule was designed to avoid litigation, like a big lawsuit, not a simple administrative hearing. But the HOA's argument was way simpler. They just said, hey, it's in the contract, she agreed to. And that contract says it applies to all claims, which is a super broad term, no matter where she tries to bring them. So you have this standoff, right? A public process set up by the state to help people on one side and a private contract on the other. It's a fundamental clash. Which one carries more weight in the eyes of the law? Who do you think the judge sided with? And the answer, well, it came down to something surprisingly simple. The judge's decision was all about the plain language of the contract. It wasn't about what seemed fair or what the state might have wanted. It was just about what the words written on that page actually said. And here it is, the key sentence right from the judge's decision. The judge wrote that the plain language of the rules, well, it prevents the dispute from going to the state agency, and it mandates, meaning it forces it, to be handled through the HOA's private process. In short, the contract won. Period. So what did this mean for Carol Root? It meant her complaint was recommended for dismissal. She was basically shut out of the public system, not because her complaint was weak, but because that contract she agreed to when she bought her house had slammed that door shut. And this wasn't just a suggestion. Here's how it became official. On February 17th, the judge makes the recommendation. Then a clock starts ticking. By March 23rd, the state agency that oversees these hearings could have stepped in, but they didn't. They took no action. And just 5 days after that, on March 28th, the judge's decision became the final legally binding word on the matter. Case closed. Okay, so that's the story of one homeowner's battle in Arizona. But the lessons here are massive, and they apply to anyone who lives in an HOA or is even thinking about it. So let's break down what this really means for you.
Here are the things you absolutely have to know. First, those HOA documents are not just guidelines, they are legally binding contracts. Second, when you sign the papers to buy that home, you are agreeing to every single word in them. Third, and this is the big one, those words can actually sign away your right to sue in a public court, forcing you into a private process instead. Fourth, be careful with broad language like all claims, because a judge might interpret that to mean literally any disagreement. And that leads to the most important takeaway of all. You have got to read and understand this stuff before you buy.
We'll leave you with this thought. You wouldn't get behind the wheel of a car without learning the rules of the road, right? Well, this case proves that the rules governing your single biggest investment, your home, can be just as important and have just as many consequences. So the real question is, do you really know the rules of your own neighborhood?